Okay, good morning, everybody.
Good morning.
Yeah, good. Everyone staying warm?
No, so far.
Should we wait maybe a few minutes?
Yes, about 2. I'm gonna call your biggest fan into the room right now, so let me just.
Okay, sounds good.
So we'll just introduce ourselves. My name is David Dos Reyes, and this is my partner Daniel Gamba. We have a law firm, LD Law LLP, which is in the neighborhood by Bloor and Dundas West. Primarily, probably let's say maybe 90% of our practice is real estate based. We also practice estates, which we're talking about today, corporate. That's pretty much.
Yeah.
So today we've been asked to present on estate sales and power of attorney transactions as well. So we'll do that, but I guess we'll wait maybe a couple minutes just until maybe other people show up.
Hi guys.
Hello.
Hi.
Good morning.
See you. How are you?
Good. So is that our
Yeah. Mariana, yes. So
Sounds
she
good.
you came highly recommended by Mariana, and that's why I got in touch with you because said you guys are great. She's like, yes, the best service for me. So,
Okay, thank you very much.
Mm-hmm.
Okay, so I guess we'll get started.
Yeah, perfect.
Okay, so yeah, like David said, today we're talking about estates, and we'll hand in hand, which goes along with estates, powers of attorney. So we'll have a little bit about that at the end. So the main thing to kind of understand with estates is when do you need to obtain what's known as your certificate of appointment of a state trustee. So your first kind of starting place would be, how is title held? So there's a few ways. You can have 2 individuals, or you can have 1. If it's 1 and that individual's deceased, you're going to have to get probate, or otherwise known now as the certificate of appointment of a state trustee. If there's 2 individuals, you have one of 2 kind of possibilities. One of those is if it's held as joint tenants. So in a joint tenancy situation, what you have is you have 2 individuals, could be 3. If they're held as joint tenants, then when one party passes away, the interest of that deceased party passes automatically to the survivors. So that's usually a very common way that title is held between spouses. It doesn't have to be spouses, but it just depends on what the intention is. It could be brothers and sisters. It would be very strange to kind of see this manner of title between business partners. For example, if David and I hold a property together, as much as I consider David a very close friend and business partner, I don't want my interest to pass to him when I pass. I prefer it to go to whoever's named in my estate. Okay? So if you do know that, okay, it's held as joint tenants, then the only thing that you really have to do is register what's known as a survivorship application. The lawyer would do that, and then the property is solely in the surviving party's name. In which case, when you're listing your agreement or your property, the only individual you're listing is the surviving party. So the other scenario, I'm just going to skip ahead, is tenants in common. So this is where you have a split interest between the 2 parties. So I'll give a very common scenario. 2 business partners own a property. They each have a 50% interest. Individual A who passes away, their interest is not going to go automatically to the survivor. It's going to go to whoever they've named in their will. And if they don't have a will, it'll go to whoever the government says it's going to go to, which is the Succession Law Reform Act. So what we have is that individual A who's now passed away, you have to obtain probate or what is known as a certificate of appointment of a state trustee. In such scenario, you are looking at a bit of a processing time, so don't jump to list in such scenario, just because, especially in Toronto, as David's gonna get to this, you're looking at about a 6-month wait time. There are some limited exceptions where the estates court will grant the probate and they'll bump it up the list if you have a signed agreement of purchase and sale, but I wouldn't hold your breath, because even in such cases, they don't answer their phone at the estate court. Sometimes the only way to even get to them is going there in person, and even then, it's sometimes like needing a divorce, getting them to move. So your best bet before listing, when someone is deceased, if you know you have to get probate, get that certificate well ahead of time. In Toronto, it's about 6 months currently. In other cities like Barrie, it's about 2. So, yeah, and that's from the time when the application's actually ready to go. Because there are a few steps that need to be taken prior to that point. So in some very rare cases, what you'll have is, if you have 2 individuals that are listed on a deed, on a transfer, and their interest is not specified, so it doesn't say tenants in common, it doesn't say joint tenancy, the default kind of interpretation is tenancy in common, which means you're going to have to go get that probate if one of those individuals passes away. So just kind of keep that in mind. We have kind of run into those situations where everyone assumes that it was a joint tenancy and that the survivorship would be the case, in which case they thought, okay, now the surviving father or mother is now the owner, and then you realize after the fact that no, you have to get probate now, and that is quite a process. There's legal fees involved, there's a state administration tax that's involved. Yeah, so just if you're not too sure in terms of how property's held, just show the deed to a lawyer. He'll be able to tell you quite quickly. And then depending on if it's a joint tenancy, great, you're gonna save a lot of time and money. If it's not, then you gotta kind of hold back on the listing, I would suggest. Yes.
If there is a will, would that make any difference?
So if there's no will in a joint tenancy situation, it doesn't matter.
If there's no
Yeah, so if you hold property as a joint tenant and you don't have a will, it's kind of irrelevant, because the property will just automatically pass to the survivor. If there's no will and it's a tenancy in common, it's not the end of the world. It just means that instead of you having a will to follow, so in the will you're going to name an executor, you're going to name your beneficiaries. If there's no will, then the government kind of sets out who the priorities are in such situation. Sorry.
You had a question over here.
That was my question. So husband and wife, the husband passes away. It wasn't a tenancy in common.
It was joint tenancy.
It was joint tenancy. The spouse needs to get probate?
No.
Oh, sorry.
Yeah, if it's joint tenancy and there's no will, it's irrelevant. You don't need to look at the will, because under a joint tenancy, the whole purpose is there's a right of survivorship. If it's tenants in common, then we have to look to the will, so you need to probate.
But if there's no will,
if there's no will, that's right. There's, under the Succession Law Reform Act, there's a system that the government has that essentially outlines all of the priorities.
Okay.
So spouse, then kids, then parents, then siblings, is the general sort of gist of it.
And what's the time frame for the government to kind of sort that all out?
Well, we would have to prepare an application, right? A
Yeah.
certificate of appointment of a state trustee without a will. So we would prepare the application, and then generally right now in Toronto, for instance, it's about a 6-month wait until the court will issue. The cost for the application is basically, well, you gotta pay the estate administration tax, which I'm gonna get into, so
Okay.
I don't want Dan to cover all of my points, so just be a little bit patient, and as well as the legal fees, the additional legal fees.
So I understood that if the successors of the estate weren't contesting any of the content of the will, that probate wasn't necessary.
No,
No.
always necessary. If it's tenants in common, the whole purpose of the manner of title is when you have a joint tenancy, 2 or 3 or more people are agreeing that rights of survivorship apply, okay? So as soon as one of the co-owners passes away, their interest in the property will pass down by a right of survivorship via a survivorship application. So that's the simplest way to do it. If they own by way of tenancy in common, meaning, let's say it's 2 people, just the simplest form, 50-50, then you need to probate. So you need a will and you have to go to court, you have to probate. Without that will and without the certificate of appointment, the court order, it's not possible in Ontario to pass the property. You need to register and prepare the proper transmission application. Any other questions?
And then just another kind of quick note. So you can have a situation where you have a husband and wife and everything is held jointly. They hold their the property they live in as joint tenants, all of their bank accounts are joint. In such situation, there really is no need for a will, because when that individual passes away, everything just automatically goes to the survivor. Now, when the last of the 2 kind of dies, that individual is going to need a will, because now that individual is the sole owner of whatever asset or real estate, and they have to decide who they're going to pass that interest along to. Or they could just add someone else onto title, which we see often. So you have husband and wife, they're getting older, and then they decide, you know what, we want to avoid the probate tax. Let's add the children on title as joint tenants, so that when something happens to us, it automatically passes to the children. We avoid the estate administration tax. But that's not to say that you may be triggering other tax implications for those children who this may not be a primary residence. So, but we'll leave that.
Yes.
When we go on Geo Warehouse, we just usually see the names.
Yeah.
We don't go on to land registry. Where do we actually see how it's registered?
It'll be in the document known as like the transfer or the deed of land.
But
So I'm not too
think
familiar with the
we-
Geo Warehouse, so I don't know if you're actually able to pull individual instruments
I don't
on
think-
Geo
I don't
Warehouse.
think so.
I don't think we are.
I
Yeah.
think they pull as much information as they can, but I don't think it always shows
Right.
the manner of title.
So I have lawyers that I work with too, and I call them, sometimes it costs me money because they have to pull a document that
Yeah.
costs you guys money.
That's right.
Is there any way to get it, how it's registered without doing that?
You could ask the client for a copy.
Yeah, if they have.
If they have their report from many years ago, say, do you have a copy of whatever closing documents that your
Yeah.
lawyer would have given you when you bought? And then if nothing's changed from that date, then you can rely on it. And it'll say right on there.
Yeah, no, I've seen an actual transfer, but other than that, the only way for us to know is to call you guys and have you pull the land
Pull it,
registry.
unless the client has the documents in their
Okay.
file. Yeah. So I think I'll take over, but back to the tenancy in common. We actually had a transaction last year that, or 2 years ago, that kind of derailed a little bit. And what happened was we were acting for the purchasers, and as part of our searches, it was just assumed, I actually knew the seller's lawyer, so we chatted about it, and he said, yeah, just so you know, husband's deceased, don't worry, we're gonna prepare a survivorship application before closing, everything's great, fine and dandy. So, comes to the requisition date, I run the property searches, and I pull the deed, and we realize that in fact, the deed that was registered in the 60s or 70s, whoever prepared it, the solicitor that prepared it, or the clerk or whoever, someone forgot to put in the manner of title. So where it says manner of title, it should say tenants in common or joint tenants. Where it's blank, which happened in our unfortunate case, then under the law, the default is tenants in common. So I had to call the other lawyer and say, hey, just so you know, a survivorship application isn't going to work on this transaction. And you can imagine the fallout. Everyone was quite unhappy. The surviving spouse, she had no idea. She was a woman in her 80s. She didn't know, exactly how they held title. But we had a situation where we had to go and probate, and obviously we could not meet the deadline of the closing date. So again, that's a big headache for clients. Our clients, purchaser clients, were obviously extremely stressed out about the whole situation. And again, it's one of those things where if you know that one of the property holders has passed away, and you're not 100% sure, I would call the lawyer and just find out, just say, can you double check to see how the deed is registered? Because you don't want to be in a position where, closing is fast approaching, and then 2 weeks before closing you realize, oh no, we have to actually probate this will, and there are going to be delays and so on and so forth. Right? Okay, so
Can I just, sorry, about the deed? Like, let's say joint tenancy, husband passes away, is there advantage of taking a husband's name off the deed when he passes away?
In a joint tenancy situation?
Yeah.
like immediately after, you can. I mean, some people, frequently you see clients, they don't get around to it for a variety of reasons.
Yes.
Emotional mostly. Sometimes people, I've had clients where, they wait years and years and years just because they feel some comfort of seeing their, partner's name on the tax bill, for instance. Like, it's as crazy as that. So personally, I don't think there's an advantage. So long as it is joint tenants, the survivorship application is a fairly standard application that can be prepared fairly quickly, and it can be registered even on the same day as the transfer. So I don't see any necessary advantage. I don't know if you have a different.
Yeah, just because it hasn't been registered, the survivorship, and the deceased party's still there, it doesn't really make a difference. If this individual wants to have all their ducks in line and have everything neat and all their records up to date, sure, let's register the survivorship right away. But that can wait.
That can wait.
Yeah, it
until
can
the
wait
sale.
even until the sale.
The sale, when they change the
Yeah,
ownership.
yeah. There's no implications to them not registering like a survivorship right away. So.
For our purposes, if we post a property like that on MLS, do we put two names as is, or we put one name as, do you know by any chance? Of the
It's-
surviving spouse and then estate off, or how do we?
What would you suggest? It doesn't really matter at the end of the day. I mean, it looks cleaner.
Just two names?
Either or, if you know that just the surviving, you can just put the surviving spouse on the agreement of purchase and sale, because in reality they're the ones who have the right to the property anyway. We're always going to get a question from the other solicitor, because as soon as they do their property search, it's going to show up as two people owning it by way of joint tenancy, in which case we reply back saying, not an issue, we're going to register the survivorship application on it before closing.
So we can put one name?
You can put one name, it's totally fine. I've seen it done both ways, it's not an issue.
Yeah, if it's two, then regardless, a survivorship application has to be registered, so, yeah. So, question?
Okay, so the certificate of appointment of estate trustee, this is the probate, so what's required, so you're gonna need the original will, which we'll have the client bring in. A death certificate, a funeral home death certificate is fine, you don't need the one from the ministry, that one takes usually a few weeks to get. A tax bill will help us out a lot to expedite preparing the application, as well as a list of all assets and liabilities of the estate. But again, this is not something that you generally need to know. We would reach out to the client directly and kind of coach them through it. Okay, so the process, so we prepare the application. The thing that takes the most time is actually getting, depending on how organized the client is getting all of the documents in order. Once we have all of that, then we prepare the application, and we meet with the client to review and sign off on everything. The other thing that has to be considered as well is the payment of the estate administration tax. Generally, if we know that the property is going to be sold sometime in the future, then we prepare an estimate of the value of the estate, and that the estimate is submitted along with the application. And as well, usually clients don't have the funds, the liquid funds, to finance the estate administration tax. So along with the application, we can prepare a motion to essentially defer the payment of the tax until the closing of the transaction, in which case then the solicitor, through their trust account where they're holding the sale proceeds, would then pay out the tax and file the final return for the client.
Sorry, the question there, is that based on the value at the time of death?
It's always at the time of death, that's right. So for the state administration tax, it's the value at the time of death, always.
So you want a letter of opinion from a professional?
Generally, our standard, I mean, it's an open question about what exactly is required if you are audited. Unfortunately, the ministry does not give the best guidelines. Their gold standard that they advise is to get done by an appraiser, like a professional appraiser. We haven't had any issues. Generally, at least my practice, I don't know what Daniel's is to get at least a letter of opinion from the real estate agent. I always ask for 3, just to have, just in case. If it is subject to audit, then you have it there. But at the end of the day, in this case, if you know that the property is going to be sold, then you prepared the estate administration tax based on the final sale price minus the mortgages.
And also just when you're determining you're calculating the estate administration tax. So you'll have, for example, the real estate property that is subject to a sale or what have you, but you'll also have to include any other assets that are held only by that deceased individual. So you have to include checking accounts, GICs, basically anything that was just in the name of that particular individual that hasn't passed by right of survivorship, you're going to include in your calculation for your estate admin tax. So I think David's going to go through like a potential example of what you're looking at in terms of estate administration tax.
Good question.
Yeah.
If there were other assets that are passed by way of a will to beneficiaries, those wouldn't then be included in that probate, would they? So a car, for instance, or a diamond ring or something like that.
You're supposed to include them.
They would be included as part of this application. That's why when we reach out to the client or we meet with the client, then we go through their assets and liabilities. So to the extent that their estate has other assets, then they are subject to estate administration tax, and we would include those assets as part of this application.
The only thing you wouldn't include would be assets that are subject to a joint tenant situation. So if you have a joint bank account and that individual owns it with his wife, what have you, those bank account funds automatically pass to the surviving spouse. So they don't need to be included for the purposes of calculating the estate administration tax. Yes.
What about RRSPs if they were going to go over to the spouse?
If they're going to, if there's a direct, if they've named a beneficiary, then yeah, you don't have to include those.
So anything that's going to pass to someone else gets taken off of the calculation?
That's right, yeah.
But that was my question. So a diamond ring, a car, something like that, if that's if there's a named beneficiary, that would automatically pass by way of a will, but that would or would not be included in that.
It would be. The RSP question was like a little confusing just because that's one particular instrument where the government allows you to name a beneficiary for the purposes of actually taking it out of the estate. But other items like just a normal bank account, I don't know, your Rolex watch, your diamond rings, things like that, they will form part of the estate. And you have to evaluate those and include them for the purposes of your estate admin tax.
So in short one, I know this is very simple, you can exclude RRSPs, joint bank accounts, and the property.
If it's held
Held in
joint.
joint.
That's
Okay.
right, yeah.
You have another question?
So I will step back a little bit. For our purposes as realtor, we're meeting with a family and we have to list a property. Okay, we go on to Geo Warehouse, we see two names and we're listing the property in one name. What should we ask for? Death certificate?
Yeah, I would ask for, so you're talking about in a
Well,
joint tenancy situation, or I guess
That's
any situation.
how we-
I would always ask, just in case, just get the will, get the tax bill, what else would you? I would ask for, if they have documents pertaining to their closing documents way back when they bought the property, those are always helpful because you can save, search costs, like some of the colleagues were saying here, where the lawyer has to pull it up, the property search and the deed. What else? I think that's it,
Most
right?
cases
Yeah.
it's joint, right? Most cases, families it's
Most
joint.
cases, but again, don't assume, like, we
Okay.
had that case happen where I acted for the purchasers, and my colleague, the other lawyer, I spoke with him, he said, yeah, don't worry about it, David.
What
they're
should
joint.
we do to determine what type of,
The best thing to do is if you're in a situation where you know someone has passed and there's a surviving spouse,
Mhm.
the most important thing would be if the client has closing documents from when they purchased the property, if they have the deed, beautiful. You can send it off to the lawyer that's handling it, they'll be able to tell you right away if there's an issue. If they are on as joint tenants, then we can prepare a survivorship application. You don't have to worry about this that I'm talking about right now.
so we can just list the property and that's it?
Yes, but I would always talk to a lawyer because you should do a property search because you never know. Sometimes you see the deed, but maybe, you know, the mom who's 80 now forgot that she transferred it in 1998 to a son just because of mortgage purpose. People forget, you know, especially as they age, they tend not to remember, or something that they thought was done wasn't done. Like that happens to us all the time where clients come in and I'll tell them, well, you know, your son's on title, and they're like, what? How is that possible? I don't remember doing that. And I say, well, yes, he's on title. You know, you did this back in 1997, and they give you that blank stare and like, oh yeah, maybe I remember there was something to do with the mortgage, or you know what I mean. So it's always better in those situations. It's a 5-minute phone call. Give us a call or call the lawyer and say, hey, I have this situation. I wanna have some comfort that I can list and I'm not gonna incur any foreseeable issues. We'll run the property search, look at the deed, confirm who in fact has an interest in the property, and advise you whether you're safe to go ahead and do your thing and list it, and then we'll talk to you after you have a firm agreement.
Best practice is just defer to the lawyer.
I would. You
Yeah.
don't want to be in a
We're not
situation.
lawyers, so-
Yeah, you don't want to be in a situation like we were in, for example,
Right.
where.
Because it can fall back on us and we
Of
can,
course,
yeah.
the clients blame everybody but themselves. They always blame you. They
Yeah.
blame us. They blame everybody.
I'd rather
right?
than blame you.
Yeah. So
than
there you
blame
go.
me.
So just pass it off.
Yeah.
We'll do the search.
Yeah, and then good luck telling a client after, oh, by the way, there's gonna be a 6-month extension to your closing date.
Right.
It's
Let
very
the lawyer say
Nobody's
that,
had
right?
it.
Yeah.
Yeah, we
Yeah.
get left with the bank, but that's okay.
Yeah, so very nice.
Okay, so the estate administration tax, it's basically a graduated tax, similar to the income tax. So for the first 50,000, it's 0.5%, okay? And then anything exceeding 50,000 is a 1.5% on the net value of the estate, okay? So for all intents and purposes, if clients are wondering, you can just tell them it's about a 1.5% tax that they have to pay, okay? So for illustration purposes, for an estate valued at $1 million, the estate administration tax payable is $14,500, okay? So again, you can see in Toronto, obviously, with the property market, pretty much anything nowadays is going for $1 million, so a lot of people don't have this kind of funds to pay the tax along with the application. So we can prepare a motion to defer the payment and then pay it out on the closing.
This tax is not paid if it's a joint tenancy, is it?
That's right.
That's right, yeah. So, good question, there you go. So avoiding a state administration tax, joint tenancy is the #1 way. There are some obscure exceptions as well that I don't want to get into because they're super, super confusing, but it's another reason why, especially if you think that the will is going to have to be probated. So if you know for a fact that the property is tenants in common and we're going to have to probate the will, speak with the lawyer very early on. I mean, it's not up to you. I just wanted to put it in your head that there are certain ways, sometimes in very rare circumstances, where we can avoid the state administration tax. Okay. We have some clauses. I'm not going to really get into them in detail. I think they're fairly self-explanatory. They're included in your handouts that you may want to consider. So the first one is basically the right to extend. Yeah, that's right. You can take this just an extra. So the first, you have it? The first clause is basically the right of the seller to extend the closing date based on when the probate application is received. Again, I don't know that this clause is super helpful. I think the best way to do it is to have the certificate of appointment in hand before you list the property, just because then you're getting into basically uncertainty. Okay, so then you don't really know when you can close, and it's not good for anyone, especially with the mortgage market these days and purchases. Things change really quickly, so I don't recommend using it, but it's there in any event. The second one is a representation from the seller to essentially say that they're moving in an expeditious way to actually obtain the certificate of appointment. Again, my advice to clients is always have a certificate of appointment before you list the property, just to avoid any issues with delays and then negotiations and all of that jazz. I think it wastes everyone's time. And then the last one here. Okay, I'm sure someone probably is going to think about how do you prepare the agreement of purchase and sale? What's the proper party to be listed? So essentially, it's quite simple. It's the estate of John Doe or Jane Doe, whoever it is. Okay, and then the signatories on behalf of the estate are what was formerly known as the executors or the estate trustees. Okay, and they're listed on the will. Yeah.
Would it not be wise to also put a clause in with the property stating that it's being sold as is, where it is, or?
I love those clauses, right? Those are
I mean,
good.
it's not really, banks don't love that clause, but it is an estate sale, so what's your opinion on that?
Again, it's up to negotiation. If you can get the purchaser to agree on something like that, then great, you're protecting your own line, right? So I would recommend it. I don't see any downside risk to having a clause like that.
Best case scenario
For
from
a
the
seller.
seller's point of view, so yeah, why not?
You
can
may
get away
get
with it.
some pushback from the purchaser, but again, that's up to negotiation. And then, so yeah, now we're gonna move into, I guess, power.
Yeah, we're gonna look at powers of attorney, Marianne.
Yeah, just the question about like what time frame is there to apply for the, like, is there a
For the
time frame
certificate,
for the certificate?
so it fluctuates,
Toronto's
we're talking
6
from,
months,
from the
No, I mean,
point you
like-
actually submit the application.
To submit, yeah.
Mhm.
Yeah, from the point you actually submit, Toronto's looking at about 6 months.
Okay, but how, like, for
How long does it
example,
take to prepare it?
like, let's say, people die and, you know, the kids wait forever to start the process.
Right.
How long do they have to start this process? Is it has to be right away?
It's supposed to be wrapped up within a year.
Within a year?
Yeah, that's kind of it's not set in stone, but that's the usual expectation.
Okay, because
What happens if the siblings they don't get along?
It's gonna cost a lot.
Yeah.
It's just gonna take away at whatever they're gonna take home.
Can one sibling remove the other as a trustee?
It's pot, again, we've seen these. Our advice, or at least my advice to clients like that, is to try to get them to agree as much as possible, because the real winners when you get a situation like that are the lawyers. That's just, at the end of the day, especially, I mean, usually it's family dynamics, relationship dynamics,
Right.
you know, I did this for mom, you were never there, and now you want to take this, and how dare you, you know, you're not gonna, I have a right, and all of this mumbo jumbo. We've all been there, we're all part of family, so
Yeah.
I kind of understand it. Usually, I try my best to get people to agree, because even from my own experience, I've had this experience, and it's never good. It's really, really expensive when you hire an estate firm that handles these contested applications. And let me tell you, they do really, really well. They do really, really well, okay? So if it gets to that, then it becomes, you know, off the rails kind of deal, and it's, you have to kind of wait until the parties either agree or they bring an application to the court to see who actually has the authority as a state trustee.
And that gets costly, right?
Really expensive, yeah. We're
I'm
talking
dealing with that
tens,
situation right now.
yeah, tens of thousands of dollars, like easy, just for the first hearing.
Tens of thousands.
Yeah, all easy. I'm not even kidding. It depends on how contentious it is, but then you have, you know, because you have to prepare affidavits. The parties prepare affidavits. They have to rely on certain documents. Sometimes they go to medical records. It gets, again, that's like the Cadillac fight. And if people are willing to spend their whole inheritance on it, I mean, it's up to them. Sometimes that does happen. It's very rare though, especially when people start realizing the cost and understanding that either they're going to be responsible for it personally, depending on how the application goes, and depending on what the judge decides, or the estate's going to be responsible. So they're going to take a hit in their pocket.
Right.
Either way, the lawyers are going to get paid, and they won't do work on an estate unless they know that the assets are there at the end of the day, that they'll get paid, right? So again, it's a tough conversation to have with clients, but I do my best. It's rare, but you do get a bit of hiccups here and there. As long as people, I find that as long as people are kept in the loop and the process is transparent, they understand where the money's going, you know, and they understand that the division of the assets are done by way of the will. Usually people agree, but if they don't, yeah, it can get ugly and very costly.
Yeah, so just before we head into powers of attorney, just a quick note. So I'm sure you guys have all come across this situation where you have an individual or two, they want to buy a property, but they can't qualify for a mortgage, and then they gotta get mom or dad as party to the agreement, just so that they can qualify for that mortgage. So a personal guarantee is not enough, they have to actually be listed on title. And then mom or dad is listed as a 1% owner. That 1% ownership, they're kind of just there for the purposes of helping their children qualify for the mortgage, but they don't really have anything really to do with the property. In such situations, if that 1% owner passes away, you're going to have to go through the probate application for just that 1%. So, just, yeah, keep that in mind. Yeah, sounds like a great idea. Sure, they'll qualify for the mortgage, but if something ever happens, like down the line, you are going to have to deal with that 1%, and it's not the most pleasant experience having to go through this whole probate just for a 1% interest.
So why people would do 1%?
For mortgage purposes, to qualify for a mortgage, and
Why
then they
not
just,
do joint then?
They can. Yeah, so that's another thing to kind of consider
The only
as
thing
well.
that I can think of is for the land transfer tax. If the kids are buying the property for their first time,
That's why,
99%, 1%, that makes a difference because then they can save on the land transfer, am I correct?
that's right, yeah.
so.
Yeah, because they would pay the 1% on the land transfer tax, yeah. That's frequently why it's done that way. And then sometimes these things are done and life gets in the way. People forget and they don't remember, and
When you switch the tenancy later, like if you did the common tenants, right, for 99.1%, can you switch to joint in a year or two? And what does it cost?
You can, you will likely face some land transfer tax implications. What some people do is, at the very beginning, they'll have a trust agreement in place, which kind of specifies who the beneficial owners are, and if you're going to just transfer it later down the line to kind of reflect what's kind of in the trust agreement, then you'll get around that land transfer tax. So, but yeah, I think I'm getting a little.
No, it's like planning that we can advise clients to do, or
It's also
at
for
least-
a personal.
Exactly,
Yeah.
exactly.
Yeah, so usually like whenever we advise clients and they want to maximize the land transfer tax credit, one person qualifies, the other person doesn't, and they're not spouses, you say, okay, let's go 99.1%, but let's do a trust agreement right now so that we confirm that notwithstanding it being registered as 99.1, the true ownership is actually 50-50.
And that gets around the land transfer tax later on, because it's an exception. So when you register a change of title, like if you want to do later on joint tenants, you can, and when you register it, you would just indicate that it's a transaction from a trustee to a beneficial owner, in which case the land transfer tax doesn't apply. So you get around the land transfer tax that way.
Yeah, but the trust agreement is just it's a contract, it's just between the two individuals. No one else really knows about it. For the whole world, everyone sees it registered as 99.1. But between the two individuals, they have a side agreement saying it's actually 50-50. So if you want to transfer it later to actually reflect 50-50, you can do so without land transfer tax implications.
And that would be just the legal fees for doing the transfer, right?
Yeah, but if you have, again, that's why we're here. If you have any questions, just call us, even if you need, just to talk it through or some bounce ideas, just give us a call and we'll let you know what we think. Don't hesitate. Like, it's a 5-minute call and your client will love you for it if you can give them a solution as opposed to a huge problem, right? So.
But these calls, are you charging for these calls or just free?
No, we encourage agents to call us. We get calls. I'm sure all of you deal with a certain lawyer that you're used to. Maybe sometimes they're not around, they're on vacation, they're too busy, they don't return your call. Give us a call and we're here to help. We'll offer you, our suggestions based on our experience, and it may work for your client, it may not, whatever, just call. We're not gonna charge you, we're not gonna say, yeah, you gotta come in and pay a retainer for a quick call, right? Like that's why we're here. So you have our cards, just give us a call, even if you need, just to bounce an idea. This situation, what do you think? Is there a way to get around the land transfer tax? Can we structure this in a different way? And we'll tell you.
Okay.
Okay?
Well, I can vouch for that. Like I've called you guys a few times, and I always had a quick response and very helpful for my clients. So, yeah, definitely. Another thing before we move ahead regarding the estate. Let's say kids put it on the market, sell it, and then they do a probate. Can the lawyer hold the money in trust? Is that possible? Like, for example, that the property sells before the probate is done, and then the lawyer, like the proceeds of the sale, is held in trust somewhere until the probate is done? Or even if the probate is a process and there's a closing date, does that happen?
You can't sell without the probate.
Yeah,
You
you
need
can't
the
close,
certificate.
because that has to actually be the certificate is actually a court order, okay, issued by the court, and that needs to be registered on title. So the actual order is registered along with the transfer, and it's once the sale, the closing date happens and the property transfers from the estate to the new purchaser, that's a public record. So that's the authority that's allowing the actual transfer. Without that, there's no way. So that's why you have these clauses that you can delay it a little bit, but that's why I recommend that you get the probate first and then list the property, because you don't know. again, it's not up to us, it's not up to you, it's not up to the client, it's up to the court. And especially in Toronto, they're very inundated and they work at their own pace. They don't take calls. They're not worried if their stack of work gets higher or lower. They just do their thing and you get your certificate when you get your certificate. There are certain exceptions, but again, it saves everyone a lot of stress if you do it, follow the process accordingly. Otherwise, then people start panicking and it's not good, right?
Is it possible for a purchaser or the purchaser lawyer to come back at the listing or the estate sale and sue the estate for any, I don't know, ramifications dealing with the listing agent or the listing or delays? Have you experienced that in terms of lawsuits against the estate that was?
Well,
I guess it depends.
we've had a few rocky, really that one that I told you about that was quite rocky where, at the 2 weeks before closing, the seller's lawyer was under the false impression that it was a joint tenancy, and in fact it wasn't, so then they had to run to court and prepare the application and all of that. In that case, my clients reluctantly agreed to an extension and everything was fine and dandy, but in theory, it is possible. Right? It is possible for a purchaser to sue the estate in circumstances where they have the legal right to sue for whatever reason. If somehow the agreement wasn't complied with or there's a breach of the agreement, then the proper party would be the estate. That's right.
Mm-hmm.
I haven't seen it personally, but it is possible. Okay.
Even after closing?
It is possible even after closing, yeah.
Okay, so, yeah.
I had a situation, I had a listing last year, and we sold it. The client said they'd done their research and they didn't need to pass probate. And then just shortly before we were going to close, the lawyer that they had, the new lawyer, was asking for probate, and they said they had to have probate. And then the reason why they didn't need probate was because it was first dealings.
Right, that's
one of the limited exceptions that we can utilize.
Yeah.
We didn't want to go too detailed into that just because it is quite complex.
Yeah. In a nutshell, how would you explain?
In a nutshell, it has to be a certain type of property which is registered under a particular type of system.
Right.
So,
it was prior to, I can't remember.
So it's called land titles qualified.
Yeah.
There's land titles absolute, there's land titles absolute plus. It's got to be land titles qualified. And in such situations, when you have a will and it's in that particular system, and there's been no transfers of title.
Yeah, or no dealings, that's where they get first dealings, then it is possible to avoid.
Yeah, so that's why.
That's why it's good to talk to a lawyer to do the property search in advance, right?
They had done that, the lawyer said that they were getting that in place, and then they had a new lawyer. So it was confusing, anyway.
Yeah. I guess not that, even some lawyers are not too familiar with this
lawyers
particular
have been
exemption.
sued on stuff like this, because it's easy to, get sometimes with the office going bananas and, someone dropped the ball and the lawyer didn't review the title search documents in time and so on, and then lawyers get sued about stuff like this. Yeah, so there are very rare circumstances where it is available.
Okay, so I think we'll jump into powers of attorney, just to kind of round off the presentation. So what's a power of attorney? Power of attorney, it's a document where you are granting the power to a particular individual to make decisions on your behalf. Usually it's used in the context of incapacity. So I write a document now, I'm fully capable, I know what I'm doing, and I say, in the event I become incapable, I develop Alzheimer's or what have you, and I can't manage my own affairs, I want to name someone that can make those decisions and manage my affairs for me. So there's two kinds. There's a power of attorney for property or finances, and there's a power of attorney for health. For your purposes, we'll focus on the power of attorney for property, just because that's what we will be most likely dealing with in the context of a sale or a purchase. So in such document, what you need to know is who's the power of attorney, so the individual that you're listening to, who's the individual that's granted that power of attorney, known as the grantor. In a particular purchase situation, when you are using these powers of attorney, just be very careful that your lender, so if this individual is buying with the power of attorney and they're taking out a mortgage, make sure you run it by your mortgage broker, that they've obtained, or that they've at least consulted with the lender that they're okay with using this power of attorney, because not all lenders will be okay with this power of attorney being used in this transaction. Some will just flat out refuse it from happening, in which case you got to look for another lender. Other lenders will allow it, but under certain conditions. So just be very careful when you are using this document. Always make sure you get a copy of the power of attorney. If you're on the purchaser side and you're using the power of attorney, the seller's going to want to see it, and vice versa. The main kind of thing to kind of take away from the power of attorney, general rules are there's got to be 2 witnesses, and the individual who's granting the power of attorney has to be over 18, and the person that's acting as a power of attorney has to be over the age of 18 as well. So, skip ahead. So the power of attorney can have some conditions to it. It can be time sensitive, so you can say, I'm giving a power of attorney to be effective from January 1st, 2019 until December 31st, 2019, and after that date it expires. You could also say in the power of attorney that it deals specifically only with a particular property. So this individual that you're giving the power of attorney to only has the authority to deal with that real estate. Yeah, so that's that.
Yeah, this is me. Okay, so power of attorney, when does it terminate? Number one is the death of the grantor. So the power of attorney is only valid so long as the person is living. The moment they pass away, people get confused all the time about this, about who has authority, who doesn't. The moment they pass away, you look to their will. While they're alive, if they're even incapacitated in the hospital, you look to the power of attorney, okay? So the moment they pass away, it's done, it's terminated. The resignation of the attorney is another way that the power of attorney is no longer valid. If the attorney, for whatever reason, doesn't want to act or doesn't have capacity, is another way. Revocation by the grantor, again, provided that they have capacity. So that's the person who prepares the power of attorney, appointing son, daughter, or whoever. If they want to revoke or change that power of attorney, they can, so long as they're capable mentally. And then the more complicated and costly way is by application to the court, where this rarely happens. Again, it could happen in an example where you mentioned earlier, where family members are fighting and there's some issues as to whether the person who granted the power of attorney had capacity at the time that they did, and so on and so forth, okay? That's where you get into the big mess and expenses. So purchase and sale transactions, yes?
So I don't know if there's any way to get around this, but sometimes when the kids have the power of attorney and they're the ones that are leading the charge for the sale, how do you know that if you can't get a hold of the grantor, that the kids aren't selling a house out from under them? Like, how do you validate a power of attorney?
You know what,
it's
actually
happened.
happened.
The person actually being competent.
Daniel has, I think, a good story. Right?
Yeah, we had almost identical kind of situations. Someone came to us it was a consultation saying, yeah, I'm acting as power of attorney. We want to list the property. And I'm like, okay, I've received the power of attorney. Took a look at it. She had come in with his agent. And so I said, yeah, looks valid. What's up with the mom? Oh, the mom's in a care home, what have you. I'm like, okay. Like at some point we're gonna have to make some efforts to like at least reach out to her. Turns out a week later after this consultation, we get a call from the listing agent. He's having an open house, and some siblings show up to this open house saying, what are you doing with selling this house? Mom is dead, and you're using this like power of attorney.
And back to the number one, death of the grantor, so power of attorney is no longer valid.
Yeah.
You gotta look to the will,
So yeah, the agent felt really foolish. Obviously the listing was taken down immediately, and yeah.
So again, you have to run your due diligence. That's why some lenders say flat out no powers of attorney because of issues like this, right? So I think B2B is one of them. B2B bank flat out says no under no circumstances unless you're in the military or something like that, which is very rare. Again, it's why at the outset of the transaction, you want to find out if you do have a lender, if they will allow it. Even from our point of view, whenever I have someone wanting to complete a transaction with the power of attorney, there are alarm bells in my head going off right away, especially if I don't know the person. Sometimes there are good reasons, like husband and wife, husband has to go away on business, and he calls me in a panic, like, David, I'm not gonna, the documents aren't ready to sign, what can we do? No problem, we'll prepare a power of attorney, you pass it over to your wife. I meet with him to sign, he knows what's going on. When the lender calls me and says, David, did you meet with so-and-so, and did you prepare the power of attorney? I can say yes and yes, and the lender's fine. They feel comfortable that I'm the lawyer acting on the transaction, I met with them, they asked me why are they doing it by way of power of attorney. Has to go on an emergency business, or a family member in, I don't know, South America is sick, or what have you. Same thing with title insurers. They automatically flag any power of attorney transactions, and the reason why, because of fraud, because of this type of situation, right? So best case scenario is we could rely on a power of attorney that's been prepared in the past, and as long as I speak with the grantor, then I feel completely comfortable. But otherwise, I don't really, you don't want to put yourself in that situation too. It's not worth that potential huge headache, right? So in our cases, I mean, we do transactions like that from time to time, but for me personally, I want to meet with the grantor, I want to know them, I want to understand why they're using this type of power of attorney to complete the transaction, and it's also helps alleviate some of the roadblocks that come ahead with when the lender calls me to find out, did you prepare the power of attorney? Did you speak with the grantor? Why are they, completing this transaction in this manner? And same thing with the title insurer. As long as I can say, yes, met with them, they're doing it because so-and-so has to go on vacation or whatever, then it's not a problem. But otherwise, you're right, there's always that concern about fraud.
Question?
Yeah.
Would you recommend, if we are on the buyer side of the transaction, to put a condition in? If there's a power of attorney, to put a condition of solicitor review or lender review prior to, signing off.
I'm just trying to understand, so your purchaser clients are going to complete, or the seller's clients are completed by way of power of attorney?
Purchaser. So just to review just to make sure that the power of attorney is actually...
Yeah, again, I always recommend that. Tell the lawyer right at the outset of the transaction that there is going to be a power of attorney. Get the lawyer a copy of the power of attorney, and then we can reach out and do our own due diligence.
Can you put that as a condition of the sale?
Sure, you can.
Yes, just review, so the solicitor can
Yeah.
review and make sure that, yes, the power of attorney is
Absolutely, especially if they agree to it. Again, it's all about negotiation
Negotiation,
and it
right.
depends on the market, right? So
Sure.
the market's changing a little bit, so maybe now you'll have
More flexibility.
more flexibility to add certain protective clauses. But yeah, for sure. Okay, so.
Just a quick question. Executor, are the executors usually named in the will only, or there's a separate document that says who is the executor after that, right? Like, because,
Yeah, so you have your will, which names executors, and they only come into play once there's an actual death. And then you have your power of attorney. The power of attorney is a separate document where the individual who's giving that power of attorney hasn't passed away, but there's a particular reason why they want to give this power to a particular individual. Maybe they're on vacation, they're out of town. It could be that they don't have capacity anymore. They're in a care home, they have Alzheimer's, what have you.
but you don't
Yeah,
need
but there's separate documents.
yeah, but you don't need the document to name the executor. The will is good enough.
That's right. Yeah, the will doesn't have any play in this at all when you're dealing with the power of attorney.
Okay, after that,
Yeah, the will will only kind of like come into play once the actual person dies.
The number of executors can differ from the number of trustees, correct? I'm dealing with a situation where there's 3
Yeah.
executors and 5 trustees, which is a big mess in terms of like infighting with the family and stuff. So there's 3 executors,
Maybe you mean 5 beneficiaries?
5 beneficiaries.
Okay, yeah. The executor is a term that's still thrown around interchangeably with the state trustees or state representative. The proper term now, I think in the 90s, the law changed and now they're called the state trustees.
So trustees, executors is the same?
It's the same thing, but even, most people still use the word executor, just, it's what people kind of remember. Under the law, it's the same thing. Beneficiaries are different.
So they can
They
differ.
may or may not be the same as the state
Okay.
trustees, yeah. That's where sometimes you're right, you will have beneficiaries who may disagree with the estate trustees or question the validity of.
They don't have a say, do they?
Technically, no, but again, if you want to bring some sort of creative application to the court saying, you know, mom didn't have capacity when she prepared this will and, you know, she meant to pick me as a state trustee, who knows? But you're getting into really messy estate litigation, right? That's where it becomes expensive and costly.
if the will is not prepared by the lawyer, right? And there is no trustee name, only beneficiaries, what then?
Well, the government has a set of rules under the Succession Law Reform Act, which gives priority to certain people in your family tree to apply to be the executor. So the first person right off the bat that has priority over everyone is the spouse. So if you die and you leave a spouse that's living, they have the first shot at applying to be the executor. If there's no surviving spouse, then it's children. If there's no children, you look to parents. If there's no parent, then you look to brothers and sisters, and then it just goes on and on and on. So that's, yeah, the government does have like a piece of law in place which dictates who the executors can be if there is no will. And the same thing goes with beneficiaries. If you don't have a will which names beneficiaries, then the government sets out how everything is going to be divided. So,
Yeah, I think the last thing that I failed to mention, it's in the handout at the bottom, the proper listing. This is a frequently asked question from agents on how to properly list out the party names. So if it is a transaction by way of a power of attorney, the proper way is John Smith by his power of attorney, Jane Doe, the attorney. Okay. Not the end of the world if you screw this up. I've seen it done so many different ways. Sometimes just the attorney. It's a fix that the lawyer can do before closing. But if you're wondering, we have the nifty handout. I hope does everyone have a copy? Yes. And we have our contact information at the top as well. I think
David,
that's it. Any questions, comments?
a state of, so for the executor, or the trustee, do you not put their names on the listing?
I've seen it done where where you do, similar to the way I've listed out the power of attorney, but you don't have to.
So you can put the
Yeah,
estate of
but
John
but
Smith.
whoever the estate trustee or the executors are,
Yeah.
if it's just one, then they're the ones who are signing the agreement.
But you don't necessarily have to put their name on the
No, you
listing.
don't. I've seen some agents put it. Personally, I would put it myself, but you don't have to. You can just put the estate of so-and-so.
And if there's 3 trustees, you can also leave that blank, you can put all 3 in,
You can if you want to, but you can leave it blank and then just get all 3 to sign.
to sign where.
Yeah, initial and sign
Sure.
where they have to sign.
Okay.
Any questions? Yeah.
Regarding succession rules of the executor, so the spouse also common law? Or do they have to?
Yeah, it is spouse now includes common law, does it not, or no?
Don't think so.
No?
No, that's the one kind of area that hasn't been updated to include common law spouses. So yeah, no, if they're not legally married, then they're not considered a spouse.
I'm dealing with a friend who's having the exact opposite. His kids, his brother's common law is claiming that she's spoused by common law, and the kids are stating no. And
There's other rights.
she's winning that battle.
There's other rights they can claim. They can claim dependency support, but in terms of them having a claim to be an executor according to the default rules, no.
What if they've paid sort of like they've contributed to the mortgage?
That's a different story.
And but it's not they're not entitled.
Yeah, that's a different argument that they can make in court. Yeah, those are trust claims and other things. But just as an automatic right, no, they don't have. Yeah.
Any
Any
other
other questions?
questions, comments?
Can we get a copy of these slides?
Sure.
Okay.
Yeah, we can send it off to you guys and we'll get it emailed out. And then, yeah, if you have any questions, so just so you know, our office is right on Bloor beside Bishop Morocco. We're on the southwest corner, adjacent to that really ugly construction that's going up. I don't know if you've noticed along Bloor that never seems to be completed.
The draft building.
And walls flying all over the place.
That's,
Yeah.
They
Lord
sent out
knows.
renderings of that building last week.
Oh, yeah, right.
They what, sorry?
But they got
They
the
sent
owners
they
out
sent
of
out
it last
renderings of
summer.
the building last week,
Hmm.
of the new design and
No, did you run?
concept, the draft building.
How many stories are they going up
26.
this time? 26? Oh, yeah, because they bought that additional land right beside it.
Yeah.
Yeah. Yeah, it'd be interesting to see that finally.
The footprint wasn't big enough for what they
And
wanted.
yeah, it already
And
isn't
High
sitting
Park
right
is
there.
there.
Well, I think.
So anyway, pay us a visit, give us a call if you need to, get a second idea or if you're, having some issue. Feel free to call us anytime or shoot us an email. And that's it. Thanks for having us. We appreciate it.